So welcome to our first expert session with Nick Wilson. Nick, I'll let you just introduce yourself briefly and tell us a little bit about your role at Andrew Jackson's.
Thanks, Sarah. I'm a partner in the employment team at Andrew Jackson Solicitors. We've got offices in York, Hull, Grimsby and Scarborough. I qualified as a solicitor in the year 2000. I've specialised in employment law ever since then. So I act for a wide variety of employers, manufacturing, retail, professional businesses, shipping, logistics, the whole spectrum really. So I advise clients on a range of matters, including internal issues such as disciplinary grievance, contracts, restructuring, redundancies, and I also represent them at employment tribunals. Perfect.
And Nick's been a partner to Quest for many years now, as our go-to for anything legal. So the purpose of today is really to share some of his tips and insight all around our Getting Ready for the Recession programme. So first and foremost, Nick, we often talk to many of our clients about getting the foundations right with contracts, handbook policies. It'd be interesting just to understand from your perspective, legally representing people, what are the more common issues you find that do end up heading to tribunal?
Well, contracts of employment are essentially the bedrock of the employment relationship. So one of the things that we come across most is that contracts sometimes don't say what the parties think they say. And obviously that leads to disputes. And the most common disputes I think we come across are those in relation to pay and benefits, where obviously if it's not written down, so obviously some people don't have written contracts at all, that's no good. You need a document there which records what the terms and conditions are. But if there's no contract or the terms are unclear, then who knows what the parties think about what the employee is entitled to be paid, what the benefits are, whether they're entitled to a bonus, how that bonus is calculated. All of these things are ripe for problems, aren't they? If the parties can't point to a document which says exactly how those things should be calculated. Other examples are if the contract isn't clear on hours of work, shift patterns, things like that. You then get issues where an employer might think that an employee works a certain shift pattern or certain hours of work and wants to change those and within the needs of the business, but then can't because the contract doesn't provide for any flexibility in changing hours. In most cases, employees are not simply going to agree to a change in hours because often it doesn't fit their domestic commitments. So it's that kind of thing where if employers really had regard to what's in the contracts and the contract said what they want them to say, they can kind of avoid all these pitfalls in the future.
No, absolutely. And I guess that would be the one thing we always say is that those documents are not a thing that is done once and never reviewed again because times change. We saw that with COVID where lots of people realised that their contracts, for example, didn't have any kind of layoff provisions, and obviously the rules with furlough went nuts about making sure that we got those in. So, how often would you recommend that businesses should look at their contracts and policies? How often would you review them?
I mean, it's not overkill to suggest an annual review. I mean, a good reason for businesses to review contracts is that on the 6th of April 2020, the law changed in terms of what should be in the basic statement of terms and conditions. And as from that date, all workers were entitled to a statement of terms and conditions, which sets out very basic terms, but there were some additional terms that weren't there previously. And even now, we've got plenty of clients who come to us for a contract review, and those contracts don't have those basic terms in which should have been in place nearly 3 years ago now. And the other key point is that those terms should be provided to the worker before the employment starts. So you've still got workers who haven't got a written contract, and the law clearly requires for them to be given a basic statement of terms and conditions. So that's the first reason, isn't it, to let them have something in writing? Yeah,
absolutely. Always an audit trail. That's our mantra. Make sure you can show that everything you're doing is in writing and it's clear. So what we did see, I suppose, moving on to more recession-ready topics, we saw in COVID, for example, lots of businesses having to really reevaluate their structure potentially as financial support got withdrawn. We saw a lot of redundancies. And I guess approaching what is the cost of living crisis at the minute, What advice would you give businesses really to help them plan for possible changes like that?
Well, what I took from COVID was that those businesses that got on with assessing things fairly early on in the pandemic, or even before lockdown began, they were the ones that dealt with any restructuring or redundancies fairly quickly. And within a matter of weeks of lockdown, I think for many of them, it was business as usual. That's my experience with our client base. Mm-hmm. There were, I know HR and employment law professionals felt there'd be a slew of work following on from that for a long period of time. But my experience was that all kind of got dealt with fairly quickly. So using that experience, I think employers should really be assessing things now, because we don't know if the recession is going to happen, but things aren't looking great. So now's a good time to start assessing your workflows, what's coming in, your income streams, how much money is going to be coming in. Can you afford your staff in the new year, that kind of thing. Are there any other ways of making efficiencies, such as changing the way that your staff work, that kind of thing? They really need to be doing that now.
Yes, absolutely. And a good time to look at where there may be performance issues in a business. So, where you may hear, you'll get the story same as I, where there are underperformers that, businesses almost tolerate over time. Perhaps they can't afford to do so going into next year.
Exactly, yeah. And particularly if you've got staff with less than 2 years service and they're the underperformers, they're not protected from being unfairly dismissed. Mm-hmm. So if you were to terminate the employment based on poor performance alone, then it's a low risk termination of employment, really, and it may benefit your business in the long run. And it's an easy way and cheaper way of doing, isn't it? Because then you're not dismissing people with long periods of notice and that kind of thing, and also protected from being unfairly dismissed.
Yeah, absolutely, a really good tip there, consideration. So if we were to consider more specifically redundancies, certainly from your perspective, what are the most common mistakes you perhaps see at your end of the scale that cause legal issues for employers when dealing with redundancy situations?
Well, I've come across many an unfair redundancy claim in my time. I think almost all of those claims will involve an allegation that the employer has failed to consult meaningfully or properly with the employee. Mm-hmm. So, that can stretch from an employer just simply telling an employee that they're redundant and giving them the P45. That's happened in the past quite a few times. Or they've had one meeting to dismiss and there just hasn't been enough consultation meetings. Or there have been meetings, but actually the employers made it quite clear at the beginning of the process that they were going to terminate the employment for reason of redundancy anyway. So a lot of the claims I see for unfair redundancy involve a situation where the employer just simply hasn't given enough consideration to alternatives to redundancy. Mm-hmm. I think employers start off on the basis that we're losing money, we need to cut jobs, we've decided who's going to go, and that's it. But actually consultation is a way of trying to identify ways of avoiding redundancy, but also giving the individual the chance to say their piece on these things. And I found that if you allow employees to engage properly in a consultation process so that they feel they've had the chance to say what they want about this, that minimises the risks of any claims further down the line. And if there are claims, at least then you can point to the fact that you've had 2 or 3 consultation meetings with this individual. You have discussed things like, this is the reason why your post is potentially redundant. We've looked at alternative employment, we've looked at alternative ways of working, short time working, pay cuts, that kind of thing. Things like voluntary redundancies might be considered, but we've come up with nothing. And unless the employee is able to suggest something either, then the risk of a successful tribunal claim is quite significantly, I think. I think of course, the main problem with employers is that they often start to undertake redundancies when there's some financial pressure on them, so they want to do it fairly quickly. Mm-hmm. The problem with doing things fairly quickly is that if you take shortcuts, you're introducing a level of risk which might not be there otherwise, and you don't need to. Is my view on these things. I don't know what you say, but I think if you have clients often ask me, how long does a redundancy consultation process last?
Yes.
Depends on the facts, doesn't it, really? But if you look at, generally it's somewhere between 2 and 4 weeks, depending on the nature of the employer and how many people are involved in these kind of things. But as I say, if employers look to take shortcuts, that's where they're introducing a level of risk which might be problematic further down the line.
Yeah, and I think some of that can also be driven on the size and complexity of a business, because, for example, you know, the waters can get muddied where you have roles that might technically be called different things, but the functionality of those roles are very similar. So when we start talking about selection pools, or, you know, how someone has been fairly selected to be at risk of redundancy, you know, it's giving that consideration, which I guess goes back to your first point, which is the planning now. Is it almost even part of that? If you as a business anticipate you may have to make cuts, then thinking about these things now, considering who would your pool really be? Are there those alternatives? Can you work or introduce efficiencies in a different way? Are pay cuts or other alternatives? You know, all that planning allows you, when you do have to push that button, I guess, to start going down that avenue, which I guess for most businesses is the last resort, not the first option. Then you're doing that well prepared, which means if speed is of essence, which it might be for some, you know, you can be at the shorter end of that time frame because you've done all the legwork in advance to show you've given these things proper thought and consideration. So I guess the planning does aid where, especially smaller businesses, might need an element of speed to going through these processes.
Yeah, I think that's right. And what you've just said, though, kind of takes us back, doesn't it, to contracts? Because how many times do you have a redundancy situation and the person's job title in the contract has never been updated?
Yes.
For so long. And then when it comes to a redundancy situation where the current role might be at risk of redundancy, it's fairly common for individuals to say, well, actually, my role is not redundant. My role is this, as stated in my contract. Now, legally, that's not such a great argument, but it presents a problem for the employer in dealing with the consultation then, because that individual's expectations about their role have always been different now when you look at the contract. And again, these are kind of issues that if you look at them at the beginning, or you review your contracts annually, you kind of stamp them out before they become really big issues.
Yeah, absolutely. It almost feels like all these years of nagging, telling clients to document any changes are worthwhile in these situations. I guess if we were to sum up, Nick, what would you say, you know, for businesses that may be ahead of a recession, what would the top 3 tips you could give them now to help prepare and plan for that?
Well, obviously, the headline here is to start planning for what might come. So they need to be reviewing their workforce requirements, their operational requirements, but also how their workforce is protected. Because again, if employers don't review their contracts of employment, they might find that the contract doesn't offer them as much protection as they think. So I often get asked to advise on restricted covenants in contracts of employment. And it's obviously, as we know, a very complex area of law, but the key point is that those restrictive covenants which seek to prevent certain activities by the employee once they've left, if those restrictions aren't binding at the time they enter into the contract of employment, then they'll always be unenforceable. They don't become enforceable over time because of a change in circumstances. So if you're a business that needs to protect its client base, its customer base, and you've got one of your best employees who's looking at leaving and going to a competitor, for example, you're going to want to know, aren't you, that you can at least customer base by preventing that employee from poaching them or contacting them for 6 or 12 months after they've left. So if you're in that problem, because you've got a contract which might not be up to scratch, now's the time to be looking at that, because there's no point when the employee's left and started poaching your clients. If you're at risk now, you can deal with that, even if it's by just getting in front of your clients to protect them that way, and making sure that they stay with your business. But so it's really just looking at everything in the round now and just seeing where the risk points are and dealing with them as quickly as you can. I think there's 2 other issues which I've looked at. The first is really looking at how your business works, because ultimately you want to maintain your workforce during what can be very difficult times. But if you are looking at restructuring or redundancy, it's going to be a period of uncertainty for those staff. What you don't want is staff leaving because they think their jobs are at risk.
Yes.
And my view on employment law is that consultation is a great thing for 2 reasons. Firstly, it ensures that if you do consult with staff, you're often following your legal responsibilities to do so. But secondly, if you give staff a chance to say their piece in the appropriate way, you keep them on side, you maintain their trust, and you might need to do that at this time, because if things are tough, you need your staff, because if you can't have your staff, you won't be able to operate. What you don't want is people leaving, then you're having to spend your time recruiting and training new staff who might not be up to the job, and that takes the focus of your business, doesn't it?
It does, and the recruitment market is a tough one at the minute, so it might not be as easy as you think to replace somebody like for like.
Exactly, yeah. So I know some clients have found it. Certain clients of mine have found it difficult to replace in jobs which traditionally they could just easily get staff, but that's not the case. So that's going to be a problem. I think the third thing is it's perhaps a wider legal issue, that consultation is great, but it does give rise to certain other obligations as well. So if you're looking at restructuring or redundancies, if you're looking at that affecting 20 or more people, might be a collective redundancy, for example, or just changing people's terms and conditions, that could also invoke the collective redundancy regulations, even though it doesn't sound the same set of regulations apply. So when you're doing all of this huge assessment of your business and looking at what's going forward, you do need to think about the legal issues that arise here, because the last thing you want, isn't it, is to embark on some kind of process and find that because you've not followed the correct law, you end up with a load of claims for the breach of collective redundancy regulations, for example. That's exactly what you don't want. So it's just about getting that done now. There's no point doing it next year when we're in the thick of any problems. No,
absolutely. Some sage advice there, I think, for coming into the year ahead. On that note, we're going to wrap up our video for today. So thank you, Nick, for joining us. What I would say to anybody watching is you'll see the contact details coming up where you can get in touch, obviously, with any of the HR team here at Quest. If you have got any particular legal issues that you would like to go straight for an advice from a solicitor on, then obviously Nick's details will also be on there. He'd be more than happy to reach out and have a chat. But in the meantime, thank you very much again, Nick, for your time and advice as always, and we'll see everybody else on our next video. Thank you.
Thank you.